Hello everyone, welcome back to my channel. Thank you so much for stopping by. Before we get into today's main topic, I do want to let everyone out there who may not already know that Johnny's defamation trial has been postponed. But before you get too excited, this is not because of Johnny's conflicting schedules with filming, but because of concerns over COVID. I will be linking an article down below if you want to read more detail about this, but this is the gist of it. At the end of the day, what matters is Johnny actually ended up getting what he wanted, even though it wasn't for the reasons that he wanted. With that out of the way, we can now turn our attention to the main topic of this video, which is Amber's latest filing. On the 4th of September, Amber filed a motion for sanctions and motions in limine. She is asking that the court orders that, firstly, Johnny's damages are limited to the scope of his discovery produced as of the 16th of August, and she also wants anything that references the charges or allegations that have been made against Amber to be excluded from this trial. And she also wants any evidence related to her charitable donations to be excluded. And finally, any testimony made by her late mother, Paige Heard, to be excluded on the grounds that it is hearsay and does not fall under any of the hearsay exceptions. All right, so a motion in limine is actually a term that is particular to US law. And for those of you who may already know, my jurisdiction is Australia. So initially, even I wasn't sure what it was. But when I looked it up, I realized that it was pretty much the equivalent of what we here call a voir dire, which, like a motion in limine, is a motion that is discussed or held without a jury, so the jury are excluded from this. And the purpose of these motions is to request the court to exclude certain evidence. All right, so the first argument is that Johnny is allegedly in contempt of court for disobeying a court order made on the 10th of August of this year for him to produce certain evidence or respond to specific interrogatories. Interrogatories, for those of you who don't know, are just questions that should be answered by the other party. So it's like you're interrogating someone. That's where the word comes from. So Amber is asking the court to sanction or punish Johnny for not adhering to the court order by limiting the scope of his evidence to everything that he has produced up until the 16th of August 2020. So they want anything that Johnny produces after that to be excluded as punishment. The way this paragraph is worded really strongly implies that Johnny has completely failed to respond or to comply with the court's orders. However, if you have a look at attachment 1, which is the first court order, there are two, the court has essentially ordered Johnny to produce certain evidence or supplement answers to a limited number of Amber's interrogatories. Now, for the purposes of making this video as concise and as brief as possible, I'm not going to go through each and every interrogatory that Johnny has to respond to, but I did do that in my own time. Johnny did actually respond to each and every interrogatory. He did supplement his answers. They may not be answers that the opposing side were after, but he obeyed the court order by supplementing these answers. The court specified two deadlines for Johnny's responses, and these are the 14th and the 21st of August. Attachment 4 is dated the 14th of August 2020, and attachments 5 to 7 are dated the 21st of August 2020, which means that as per the court order, Johnny filed his responses by the due date. If he had failed to do so, then he would be in contempt of court. Now let's look at a couple of examples to see whether Johnny did actually supplement his answers or produce any requested documents. So with regards to interrogatories number 11, 14, and 16, the court merely asked Johnny to supplement his answers. And if you go to attachment 4, you will see that interrogatory 11 has the original answer in addition to the supplement answer. Interrogatory 14 has the original answer in addition to the supplemental answer, and the same can be said for interrogatory number 16, which means Johnny has complied with this specific order. And like I said, the answers may not be what Amber wants, but that's not what determines whether Johnny satisfied the court's order. He was ordered to supplement his answers, and he did exactly as he was ordered. The court released a second set of orders on the same day, the 10th of August, in which Johnny was ordered to respond to further interrogatories and requests for production. Again, I've gone through the interrogatories, and I'm fairly certain that Johnny has, in one way or another, responded to each and every one that he was ordered to respond to, but I will pick out one more example to see whether he has actually done so or not. So let's look at the first court order, for example. Johnny was ordered to supplement his answers and substantively respond to defendant's first requests for admissions, numbers 11, 12, 13, 14, and 15. We can find our answer in attachment number 7 for this specific court order. On page 8 of attachment 7, you will see that the requests for admission section begins. Specifically, requests 11, 12, 13, 14, and 15 all been provided with a supplemental answer, as you can see. So like I said, there is a list of interrogatories and requests for admission that are included in these documents, and it would take forever for me to talk about them on camera. But the main purpose of this is to illustrate that Johnny has obeyed the court's orders to supplement his answers. And there are also court orders to produce documents. But don't forget, you can only be made to produce documents if you have them, if they exist. So for example, in interrogatory number 1, where Johnny is asked to provide evidence of any gifts that he may have given to previous romantic partners apart from Amber Heard, Johnny clearly states that he will be happy to provide non-privileged documents relating to these gifts, if any. That means he may not have this evidence. He may not have these documents. So failing to produce them doesn't mean that he has disobeyed the court's order. It most likely means he doesn't have them. There's even an issue about the relevance of these questions, and I certainly have my personal issues with the relevance of a lot of these questions, including this specific interrogatory number 1 with relation to gifts. I don't see how it's relevant. Maybe they're trying to insinuate that he's bribing these women to not come out and talk against him and to say that he's abusive by nature. But the court did order him to supplement his answers and to provide any additional documents or additional evidence. So clearly the court was convinced that this was somehow relevant to this case. All right, moving on to the next claim, which is limiting Johnny's damages to the evidence that he has provided up until the 16th of August of this year. Amber is arguing that Johnny has failed to provide any tangible or verifiable independent evidence regarding the effect that the op-ed has had on his career. His answer can be found in interrogatory number 16, page 13 of attachment 4. First of all, he states that her defamatory statements constitute defamation per se. So damages are presumed in defamation per se. There's no need to prove actual harm, which is true. Johnny further goes on to specify that his claim for monetary damages is supported by the fact that his reputation and career have been severely damaged. So they're arguing that this is an obvious side effect or consequence of being accused of being a wife beater or being accused of abusing his wife. They further go on to say that although this is obvious, they will further supplement the economic impact of these defamatory statements by way of expert analysis. And the assumption here is these will be reports from financial experts. The most important piece of information that they provide here is the fact that Disney announced that they were dropping Johnny from his role as Captain Jack Sparrow 4 days after Amber's op-ed was published. And finally, Johnny specifies that the claim of $50 million is a number that is based on his prior earnings from playing the role of Captain Jack Sparrow in Pirates of the Caribbean. So the other side want actual proof of this, which is a fair request. But again, we have to remember that Johnny is claiming defamation per se, so no proof of actual harm is required. Of course, it will vastly help his case, especially in the eyes of a jury, if you can actually provide tangible, irrefutable, objective, or independent evidence of the financial impact and even the career impact, the reputational impact of the op-ed on Johnny's career. But at the end of the day, defamation per se does not need actual harm to be proven. So Disney has actually agreed to have a conference with the court on the 16th of September 2020. And one concern I do have about this is whether Disney will be questioned about their decision to drop Johnny from his role as Captain Jack Sparrow, because Disney might completely deny that the op-ed had anything to do with it. And that would be a major blow to Johnny's claims because it is an integral aspect of his defamation claim. I do think it's too much of a coincidence that he was dropped 4 days after the op-ed was published. But we have to keep an open mind here. We have to entertain the notion that maybe, somehow, there was at least a 1% chance that Disney was always planning to go along this direction of replacing Johnny with a female lead. So that's a potential sticky situation for Johnny. Because even if they did let him go because of the op-ed, I don't see them coming out and admitting it, especially now that all of this evidence is coming out against Amber and in support of Johnny. And my hope is that the jury will understand that it would not be in the best interests of Disney to openly admit to the connection between the op-ed and their decision. All right, moving on to Amber's requests to exclude certain evidence. And this is where things start to get a little bit more technical in the sense that we will be looking at rules and how they apply to her requests. But I will, as always, try to make them as clear and as easy for you to understand as possible. So Amber is seeking to exclude any evidence of any charges or allegations made against her that did not result in a conviction. Of course, this includes her arrest in Washington State for assaulting her then partner, Tasia Van Ree, the dog smuggling incident in Australia, and finally lying to the authorities about the status of her friend, Savannah McMillan. Okay, so to be honest, I'm not sure how these rule numberings are referred to in Virginia because I've never heard someone say them out loud. So forgive me if I say them wrong, but her defense are relying on Rule 2609, that's how I'm gonna say them, which is impeachment by evidence of conviction of crime. And that rule reads, evidence that a witness has been convicted of a crime may be admitted to impeach their credibility, subject to a couple of limitations. And these limitations are basically that the details are not to be provided during examination unless they are offered as rebuttal evidence. So let's say a witness has denied any of these convictions, then the prosecution can use details of these convictions to rebut the denial. So the way it reads to me is that her legal team is claiming that only the fact that someone has been previously convicted and the number of these convictions can be talked about without the detail, as I just said. So they're arguing that because there have been no convictions, then these details should not even be admissible in the court. But the way I read the rule is that it's only dealing with convictions. It doesn't necessarily exclude evidence of charges or allegations or previous run-ins with the law that did not result in a conviction. Please remember that I do not practice in Virginia and I'm not familiar with their rules and their procedures. This is just the way I'm interpreting it using my skills as a lawyer. So that's the rule that they rely on, and they rely on one more, but we will get to that because I've gone ahead and looked at all the other rules, or at least all the other rules that I could pick up. I mean, there are probably more rules that apply to this certain situation of adducing this evidence against Amber. If you look at Rule 2607, impeachment of witnesses, it states that in general, the credibility of a witness may be impeached by any party with any proof that it is relevant to the witness's credibility. It goes on to list all the various rules in the Virginia Rules of the Supreme Court that can be used to do this, and Rule 2609, which is evidence of prior convictions, is one of these ways. If you look at subsection 7, it states that any other evidence not covered in the rules can also be used to impeach a witness. And subsection 8 states that evidence that is relevant to the credibility of a witness can be used to impeach them if it has a logical tendency to show the trier of fact, which is the jury in this case, that the sincerity or veracity of the witness is questionable. So as you can see, this is quite a broad rule. It allows for a lot of instances in which a witness can be impeached, as long as the evidence is available to do so, and as long as it has the tendency to show that the witness shouldn't be trusted. Going by this rule alone, and I am going to be looking at further rules, we're not going to stop here, I would argue that evidence that she has lied to both the Australian and US authorities can be admissible purely with regards to her credibility. So purely to demonstrate to the jury that the sincerity and veracity of Amber is questionable. Because let's not forget, this is a defamation case, which means that the credibility and the honesty and the veracity of the author of the defamatory statement is a fact in issue. Because what makes a defamatory statement defamatory is its falsehood. That is the first and foremost element, a false statement. So an integral part for Johnny to win this case is to demonstrate to the jury that Amber is lying and that she knew she was lying, because that's what actual malice is. For the most part, you can also have a reckless disregard for the truth. So in order for him to successfully win this case, he will have to adduce evidence to give the jury pause and cause to question Amber's veracity and sincerity. Another relevant rule is Rule 2608, which has actually been brought up by her defense as well. And that rule concerns impeachment by evidence of reputation for truth-telling and conduct of witness. Before I go any further, this rule is listed as one of the many ways, not the only way, that a witness's credibility may be impeached. So even if this one doesn't work, we already discussed Rule 2607, which, according to my interpretation, could potentially work. In this rule, reputation evidence of a person's truthfulness or untruthfulness may be used to attack the witness's credibility. The proviso here is that the person testifying about the reputation of the witness must be familiar enough with the witness, because you can't really talk about someone or their reputation without knowing them on a personal level or being familiar with them. A good example in this case would be Amber's ex-assistant, Kate James. Of course, Johnny knows her personally as well, but in this case, it would be he said, she said, and it's always helpful to have an independent third party to back up a party's evidence. A limitation of this rule is that specific instances may not be used to illustrate this reputation. So that means that the specific examples of lying to the authorities cannot be used unless subsection C kicks in, which is someone testifies about Amber's truthfulness. Only then can specific examples be used by the opposing side, being Johnny, to challenge this testimony in cross-examination. There is an important rule to mention here as well, which is Rule 2403, exclusion of relevant evidence on grounds of prejudice, confusion, misleading the jury, or needless presentation of cumulative evidence. This is a very common rule that I am very well aware of because we have the equivalent of it here in Australia as well, which is that evidence can be excluded if it has the danger of being unfairly prejudicial to a defendant, and this unfair prejudice outweighs its probative value. So for the most part, evidence adduced by the other side, by the prosecution or by the plaintiff in this case, will always in some way be prejudicial to a defendant. So the goal here is not to keep out any evidence that will cast the defendant in a bad light, because in that case, no evidence will be admissible against the defendant. Here, it's a balancing act between probative value, or the weight of the evidence, and its unfair prejudice against the defendant. If probative value outweighs the unfair prejudice, then the evidence will be admitted. If the unfair prejudice outweighs the probative value, then it will most likely be excluded. Arguments can be made for and against with regards to this rule. It just depends on how well the arguments are presented and whether the court will be swayed one way or another. The final rule I want to talk about is Rule 2404, which states that character evidence is not admissible to prove conduct. Now, there is an exception, which I will get to soon, but I do want to talk about Johnny's purpose for trying to adduce this evidence against Amber into trial. The main purpose of this evidence goes towards her credibility. Now, will they have a side effect of painting her out to be a person of bad character? Yes, of course. But that's not the main purpose here. If you look at subsection B, it states that evidence of other crimes, wrongs, or acts is generally not admissible to prove the character trait of a person in order to show that the person acted in conformity therewith. An example here is evidence that she assaulted Tasia Van Ree shouldn't be admissible to show that she has also assaulted Johnny, or evidence that she has lied, shouldn't generally be admissible to show that she has lied in this instance as well. But there is an exception within this subsection, which mirrors the rule that we just discussed, the issue of probative value versus unfair prejudice. So the exception here states that if the legitimate probative value of such proof outweighs its incidental prejudice, such evidence is admissible if it tends to prove any relevant fact pertaining to the offense charged. Which means that if evidence of her lies or of her assaulting her partner is found to have high probative value and tends to prove a relevant fact, her truthfulness here is a fact in issue. There is no denying that. That's what a defamation case centers on, as I already said. Then it can be admissible. So again, this is a matter of how well a party argues their case to the court. With regards to her charitable donations, her defense team is relying on Rule 2608, and they're basically relying on that rule to state that specific instances may not be used to impeach a witness's credibility, only general reputation. And they're claiming this because Johnny wants to use this example of challenging the fact that she donated the divorce settlement money to charity as further proof of her tendency to lie and further reasons for the jury to doubt her sincerity and her veracity. We've already discussed Rule 2608, so I'm not going to go over how this applies to this argument all over again. But essentially, like I said, if someone from her side testifies about her truthfulness, then specific examples, including this one, the charitable donations, can be used to rebut that. I hope Johnny's legal team will successfully argue why this evidence has such high probative value that could outweigh any potential prejudice caused to Amber purely because it goes straight to her credibility. For the most part, perhaps evidence of her arrest in Washington state may be ruled as inadmissible because the main issue here is whether she lied in the op-ed as opposed to whether she has a tendency to abuse her partners. This is not a criminal case for domestic violence. This is a defamation case. That may be ruled as inadmissible because its unfair prejudice may outweigh its probative value. Finally, the hearsay from her late mother, Paige Heard. Now, this is specifically with regards to Jennifer Howell's declaration, which we did discuss in great detail in a prior video. If you'll remember, Jennifer had a whole paragraph about Paige allegedly telling her that Amber was violent towards Johnny and that she couldn't help herself, she loved him too much. Amber's defense rely on rules 2803 and 2804, which are in relation to hearsay exceptions. And they're basically stating that Paige's hearsay statements to Jennifer Howell do not fall under any of these exceptions. Now, I went ahead and looked at both of these rules, and it does seem that Amber's team make a valid point with regards to this specific instance. I don't see any exceptions that apply to Paige's statements, and her words are hearsay because they were made out of court, and her words are trying to be introduced as evidence to prove that a certain fact is true, which is that Amber abused Johnny. Now, don't forget, hearsay rules exist for a reason. Paige is no longer with us, and it's very important for these statements to be backed up by their author. And since the author is dead, they can never be verified. So I wouldn't be surprised if that entire paragraph of Jennifer Howell's declaration is ruled as inadmissible. That's it for this video. I know it got a little bit technical there when we started talking about the rules. I would like to remind you that I interpreted these rules to the best of my abilities as a lawyer, but I am not familiar with Virginia's rules and procedures. I had to discover them and read through them and interpret them for the purposes of making this video, so there will always be a margin for error. I hope this video was informative, and I hope I helped to clear things out for you. Let me know what you think in the comments below. Thank you so much for watching. Stay safe, and I will catch you in a future video.